the Trump DC trial date. Okay, what's the latest?
The judge set a ridiculous date, a date that even some of the looniest lefty lawyers recognized was really bad. That you even had some Democratic hacks out there. There's the media hacks that are just making up law and legal claims. It's just incredible. But at least some of them are like, oh, this is kind of bad.
Well, Robert, you're sparing the punchline. A 6-week trial starting on March 4, the day before Super Tuesday, in D.C. with a judge who seemed to have been coordinating with the other judges to make sure they could keep Trump locked up in trial March, April, May, June, and for the rest of his life. Sorry. So, yeah, go on and tell us why it's preposterous.
I know of no example, nor could the government cite an example, where any case with this amount of discovery has ever gone to trial this fast in the history of federal courts.
12.1 million pages of documents. But, Robert, they say there's a lot of duplicates. So once you've sorted out the duplicates, then you can get to reviewing the 8 million documents that are left.
Yeah, exactly. And that's just the document side. That does not include all of the witness interviews, which they admit there's something like more than 200. So you got to go through hundreds, and they didn't say how many hours those are. So, you're probably talking about 1,000 hours of interview time alone. So and that doesn't include all the legal issues. She's requiring motions to dismiss because the court needs lots of time just to deal with a motion to dismiss, by the way. It's always interesting. The courts are like, you defense lawyer, you can go through millions of pages in no time. Oh, but I need at least 6 months to hear a motion to dismiss. Oh, really? So it takes you 6 months to rule, but I'm supposed to have 6 weeks to draft it. How's that work? The judge is a fraud, as the New York Post printed. She's the scion of a bunch of communists, foreign communists. We have a foreign communist on deciding the future of the 2024 presidential election. That's how insane it is. The credit to Congressman Gates, who said at a minimum there should be a congressional reprimand considered, and in my view, they should start to escalate towards impeachment. Because this is a judge who's violating her oath. This is a judge who is prejudiced and should not be presiding over proceedings. She's violating, and according to Democrats, right, their Supreme Court proposed legislation, violating your ethics is grounds for impeachment. Okay, well, this judge is violating her ethics because she is clearly compromised and conflicted by her own words on the record, because all these judges had to yip, yip, yip when it came to January 6th sentencing. She made clear she thought Trump already belonged in prison before the indictment was even brought. So, and here she is coordinating, not with the Republican appointees in Georgia or Florida, but the Democratic appointee in New York about how to coordinate the attack on Trump. This is not within her proper protocol or procedure. Quite frankly, she shouldn't be having such conversations. If any such conversations would even take place, all counsel and all parties should have the opportunity to be present. That itself, in my view, is another additional ethical breach and breach of her constitutional obligation. But it is utterly absurd. In any case, put aside that it's Trump, put aside that it's right in the middle of the 2024 election, put aside that she's trying to schedule this so that Trump has to be in trial during all the key primaries because he has to be there. He's not allowed to waive his appearance. So he has to be in federal court all of March, all of April, and given how the trial is scheduled, all of May. In other words, during all the primaries. She is prohibiting him from campaigning.
Robert, it makes me angry because it's so egregious that the only people who there's no one on earth dumb enough to not understand this. You can only be a liar and a fiend. Chris Christie seems to be both. There has not been any case brought to trial within, 6 months, ever. Judge didn't have one, prosecution couldn't find one, given this volume of stuff. The judge keeps saying, I'm not treating him any different than anybody else. And I don't have to worry about, it's none of my business if he's got a job or whatever. Like if it were a doctor who had life-saving surgery, am I wrong in thinking the judge is lying here? Like it's not true that if it was someone with a sufficiently, like the World Series baseball player, they might schedule the trial around the World Series if they make it to the final. Am I not wrong in thinking that?
It depends on the circumstance. But what's unique here is this is election interference. This is a First Amendment issue. So treating a running for the presidency and the peak of the presidential campaign as no different than any other person's job is just ridiculous. It ignores the First Amendment consequences of the prosecution. And so it reflects, and quite clearly, she chose the date to punish Trump and to hurt his election chances. She did it for impermissible First Amendment reasons. She's lying when she's saying she's treating him like anyone else, because if he was treated like anyone else, in misdemeanor January 6th cases, she extended for at least a year before trial.
People need to.
So what's her excuse on this one?
People need to understand this. A few people have been pointing this out. It's patently obvious. Those cases for the Jan 6, or some of whom were in jail pending their trials, which were not speedy at all, complicated, need delays because the delay punishes the defendant. Here, it's totally simple. It's just the former president leading candidate rushed to trial because it penalizes the defendant.
Well, she made even more clear. She threatened defense counsel that they can't even use survey evidence or to show that the venue is prejudiced, because she knows as well as everybody there's no chance of a D.C. jury being impartial, that you cannot get a constitutionally appropriate trial in D.C. if you're named Donald Trump or anybody connected to him, but especially if you're named Donald Trump. So what did she do? She said that they have to tell her before they do any surveying, because she would consider that trying to taint the jury pool. This is a long-standing abuse of judicial power. It has no business. Judges occasionally try it with me, and I push back very quickly. It's like none of your business. It's called the First Amendment. You got a problem with it, step down from the bench, because you got no business being up there. You have a right to speech. You have a right to defend your client in public. In order to have impairment of the jury, Supreme Court has made this clear. You've got to show that it's got a substantial risk that you cannot get a impartial jury, and that has to be based on impermissible, inadmissible information, so inflammatory and so pervasive and so close in proximity to the jury that not even jury selection can filter out the bias. All right. This is, don't go on national TV, local TV, every single radio, the day of jury selection or the day or two before, is talking about inadmissible evidence, right? That's what that's for. Every lawyer knows it. Every judge knows it. So this judge was lying again, misusing and abusing her power again, violating her ethics again, when she threatened them that if they develop the evidence in support of their Fifth Amendment right to transfer venue claims, she will try to hold it against them or prevent them from doing it. So, this is I said from the beginning. Now, the one mistake made by Trump's defense team, I said from the beginning, file a motion to disqualify this judge out of the gate. When you have a biased judge, you cannot sit there on your hands. And this happens all the time. And so and usually this is the response I always get from other lawyers. Oh, don't do that. The judge will be mad. I'm like, think about that for a second. If you think telling the judge you think the judge is impartial, is partial, not impartial, and that consequently it will prejudice your client's rights, and you think the judge will be adverse to you because of bringing that motion, that's exactly when you have to bring the motion, because that's how partial and prejudicial the judge is. There's no better proof of it than judges that would punish you for bringing that motion. It's like saying don't assert your First Amendment rights because they'll retaliate against you if they do. That's exactly the kind of person you have to assert your First Amendment rights with. And here, Trump's lawyers made a mistake by not, Trump himself said he wanted it, publicly said he wanted a motion to disqualify brought. And his lawyers are like, oh, I don't want to upset the judge. Maybe they won't be mean to me. No, this is a corrupt rogue judge. Put it on the record. Go at it. Deal with it up front. You can't let her continue to screw, because then what the judge will say is, oh, you're just mad at my rulings. And they like to weasel out that way. Don't wait for the judge to prove their prejudice. When you know they're prejudiced, put it on the record from the get-go. And if they're going to punish you, it further documents your case, further substantiates your case, both for appeal and for the court of public opinion. You bring the motion to disqualify early because that's an appealable denial. And people are confused out there with appeals as of right versus appeals as interlocutory or writs. Dershowitz has explained that you can bring a lot of these appeals as interlocutory and writs. Yes, they don't have to take it. Everybody knows that. Supreme Court doesn't have to take anything ever. That should not be your guiding principle. Does it give you the opportunity to knock on their door? And when you have a judge that is way past any degree of logic or reason or ethics or morals, and is out to rig the trial against your client so that she can rig the election. She's involved in a criminal conspiracy to deprive the American people of her rights. According to the theory of Jack Smith, it's this judge that belongs in federal prison, not the people she wants to lock up or has locked up. And you cannot sit there and play nice with those kind of rogue judges. A corrupt king does not respect deference. When you bow before them, they cut your head off. They only respect it if you expose them for who they are, is the only chance you have. Might the judge still screw you? Absolutely. But that meant they were always going to screw you. So play out what the probabilities are. Does it give you any chance of relief or any chance of improvement to be able to bring the motion? They needed to bring this yesterday. They need to start bringing it now. And, Trump's lawyers have been so far, frankly, mediocre. And they need to, this is the most constitutionally consequential case in the history of our country. It's not here for mediocrity. They need to step it up, quit being wusses, quit hiding behind things, quit worrying about their license, quit worrying about what the government can do to you, because you keep doing that, you don't live. That's this is what Nelson Mandela, Medgar Evers, the great quote, I gave it on Donald Trump Jr.'s interview, that I learned as a kid. Medgar Evers' famous statement when they asked him why he wasn't afraid to die, and this was a man who ultimately was assassinated on his front lawn. I said, most men die 1,000 deaths every day. I'm only going to die once. If you're going to be a lawyer and take this case, you need to have that mentality and that mindset, or they will steamroll you.
Playing devil's advocate, or maybe just, the counter argument now. They can't undo what has not been done. They can't do what has not been done. But now they have more fodder to the argument for a biased judge, the statements made in the past, and this patently
unfortunately, here's what the judges do. They say, oh, you're just complaining about my rulings.
Yeah.
And so it always undermines your ability to bring a disqualification motion. Yes, absolutely, go ahead and bring it now. No doubt about that. But the problem is when you wait for the judge to make a ruling, even the higher courts look askew at you if you didn't bring it before they made the bad ruling. Because otherwise they think this is just a disguised appeal of the ruling you don't like. And that's why you had to bring this right out of the gate. You had to put them on blast. Know what they're doing. You know what they're doing. You got to say it, take the heat, roll with it, and act accordingly. And put them to the test. If you play ball, if you play nice, they will steamroll you. And that's what this judge is doing to Trump's team.
It's almost like a joke. Like, it's an in-your-face needle. I'm going to start this trial the day before Super Tuesday. Can you, first of all,
the lawyer, to his credit, Trump's lawyer said, by the way, this guarantees ineffective assistance of counsel. We cannot prepare in that time. We cannot. It's impossible. And she didn't care, right? The goal here is clearly not only derail his campaign by having him in trial the whole time, have that be the national news narrative, that trial, rather than what he's saying on the campaign trail. Have that be the national news narrative rather than Biden be the national news narrative. But the goal is to try to convict him before the election day. They believe as long as they can convict him before election day, that enough of his voters will abandon him, and that will defeat his campaign. Now, I think they're wrong on that assumption, but putting that aside, it's clear this is pure election interference. This indictment is itself the conspiracy. The indictment that accuses Trump of conspiring to deprive people of their civil rights. The indictment is the conspiracy to deprive the American people of their civil rights.
You cannot repeat that enough, but people have to also understand and explain to it the impropriety. Judges are going to talk. They're going, judges, they meet at a fancy cocktail party. They go, oh, you're on the Trump case in New York. I'm on the Trump case in DC. Can you explain how transparently improper it is for her to ex parte, without the other parties being present, call up the New York judge or however the hell it happened and coordinate for the trial? This is
completely. You're attempting to impact the defendant's rights without the parties being present or their counsel being even aware. And that's patently unethical. Put it this way, if any of the Trump's lawyers had done it, they'd be in jail. So how is it okay for the judge to do it? It's not okay for the judge to do it. That if you want to coordinate that, I've been in cases that have conflicts. Mm-hmm. What happens is the court lets everybody know and everybody's on the conference call. That's what happens. And really, it's, hey, your New York case isn't as good. My federal case, we got it really rigged here with the D.C. jury pool. You think it's mine, right? Ha, ha, ha. Right? No transcript of this communication she had. I mean, this is a judge. Again, she comes from foreign communists. That's how she thinks. That's what we have. We have a foreign communist on the federal bench running this trial. People should be screaming at how insane that is. Even Murdoch, of all people, with his New York Post, had put an editorial saying, "This is kind of a problem." So they should just hammer. And I get everybody scared to ever point out anything they don't like about a judge because they think somebody's going to smack or whack them around. I've had cases where people say, don't be mean about the government. Don't be mean. Don't say anything that the judge won't like. You can't behave that way. If you believe what you're saying is honest and accurate and it's relevant to the proceedings and constitutional rights and liberties, it's your duty and obligation on behalf of your client to say so. Not stay silent, not stay mute, not because then ordinary people think lawyers are part of the problem. They think they're part of a corrupt insider system, that they're scared to point out the truth.
A lot of them do, Robert. I mean, a lot of people say they're just playing ball. It's good for everybody. They get to bill more, yada, yada. And I know you've said it before, but it's worth repeating, and I'm going to snip and clip this. What are the legal remedies to sanction that judge? Impeachment is the only one, and who has to start that process?
The House of Representatives. So that's really it. Only the House of Representatives and the Senate. Obviously, the Senate would never convict. But it's long overdue. These judges are weaponizing the power of the judiciary, and it's similar to what Samuel Chase did. Arguably, Samuel Chase was not as egregious. Back in the old days, Supreme Court justices actually presided over trials. They actually rode circuit. That's where the Circuit Court of Appeals comes from. And Chase went after his political enemies as a judge. And so one of the first ever impeachments was of Supreme Court Justice Samuel Chase. And I agree with some of the legal principles that said that what he did didn't cross the line of impeachable conduct, but it was darn close. But you know what that did? That impeachment of Chase? Courts all of a sudden were like, oh, hold on, maybe I shouldn't weaponize my judicial power to take out my political adversaries. They can do that to Chase. Maybe I should be chasted in what I do. Be a little more chaste in my behavior. And I think it's politically necessary and legally and constitutionally justified because this is getting way out of hand, and you can tell people in D.C. are clueless. They don't recognize they're jeopardizing the entire future of the country. This indictment now goes way past Trump. If they had Trump on like an actual murder charge, an actual crime, maybe then it would be different. I still think then it should be stayed until after the election so it doesn't interfere with the election under First Amendment selective prosecution and First Amendment free expression and speech principles. But at least then it'd be a different story. These are overtly, openly political cases brought by overtly, openly political judges to have lynching juries and lynching judges prevent the American people from electing who they want president of the United States. And that's unprecedented in our history. And if they are successful, they will wreck the country.